money out of this.
I did not find any evidence of that.
And that's what I mean by personal gain. Did she, is there any sort of, there's no promotion of any sort, correct?
Well, the event was promoted. I don't know what, are you promoting, are you talking about a promotion at work or what?
I'm giving you examples because you see. So typically in a fraud case, somebody's trying to gain something, to benefit you, but maybe a bad check for money.
Okay.
In your investigation, you agree that Michonne did not receive any personal gain.
Well, the outcome was the votes were not counted by Vice President Pence. So is that the personal gain that you're referring to?
Did anybody offer her money?
Again, I said
No.
that I didn't have any evidence that anybody offered her money.
Mr. Shire, I want to ask about it. As part of your investigation, you obtained a search warrant for Give, Send, Go, LLC,
Yes.
and that was focusing specifically on fundraising efforts for legal defenses, as detailed in the search warrant, correct?
No, the focus was the statements that were made on Give, Send, Go.
Did you write the search warrant?
Yes, I would.
You agreed in the search warrant you pursued detailed information about legal defense fundraising actions and communications related to fundraising platforms.
I would have to refer to the affidavit itself to say that. So the focus was statements that were made on that platform.
But you did request for financial information in the search warrant.
I'm doing that to determine if who the account is owned by, and to determine if the person that has their picture on that page is actually the owner and the person that may be responsible for inputting that information.
How did that come, you didn't request a warrant, I'm sorry, you're trying to show who owns what?
Who owns the account? Who owns the account? The Give, Send, Go account? Who made the statements? That's what I'm trying to determine. And so the more information that I could gather to support that, that's what I did.
You specifically looked at Michonne Maddox's Twitter account, correct?
Yes.
And you looked at her Facebook account,
Yes.
and you screenshot and included all things you found relevant in your investigations, your reports, correct?
Yes.
Before going into Twitter, just back to the Give, Send, Go, just briefly, who came up with the idea to subpoena Give, Send, Go?
Subpoena them or search warrant?
Either way.
I don't recall that. Again, when I work with my boss, and we kind of collaborate and we talk about that information. So I don't recall specifically.
And so was it something that you were investigating and you came upon this page and decided to issue the search warrant, or was it something presented to you?
So again, after the defendants were charged, I continued to monitor social media, and almost daily I'm reviewing that information. And so how I came about it, I don't recall unless it's documented in a report.
So you don't recall somebody gave this information to you, or not?
I don't. There's such a large amount of information about this event, this case out there, so I don't recall how I came across it.
I want to go back to that. I want to ask you about what your investigation produced of Michonne's Twitter account. and you agree that she tweeted on December 14th, 2020, the date at which this document was signed.
Again, I'd have to look at the tweets to recall that. Again, there's search warrants done to Facebook, Twitter, Instagram with thousands and thousands of pages of information.
If I showed you a copy of your incident report, would it refresh your recollection?
Yes, sir.
Your Honor, may I approach? Yes. Thank you.
Okay. Okay, I can't read the second photo here, but I can read the first paragraph and the, looks like the Twitter post.
You're able to read in the black section? The
Yes.
actual post?
Yes,
Has your memory been sufficiently refreshed?
yes.
You agree that Ms. Shawn herself stated that they did not replace any Democratic electors.
That's what she said.
And you agree this suggests an intent to operate within the law.
I don't recall reviewing that portion, an intent to operate within the
No,
law.
and I'm sorry, she didn't state that. But
Okay.
Do you agree that the fact that she, on the day of that this happened, stated that they did not replace any Democratic electors?
She did say that.
Yes, and my follow-up question is, do you agree that this suggests an intent to operate within the law?
I can't speak to what was going on in her mind with that specific statement.
Do you agree that in this tweet, Ms. Shawn explicitly clarified that their actions were intended to send their pledges to Washington?
The word pledges is in there. I don't, again, give me a second, look at it. I don't remember pledges in there. But I remember saying votes, sending our votes.
And this, a crime like this has not been, do you agree this is basically a crime of first impression, and charges like this have never been issued for this type of behavior.
Okay.
So, I mean, do you agree with that?
I'm aware of the fact that we've charged 16 people here in the state of Michigan for this purpose. I'm not aware of the cases that may be active in Wisconsin or Nevada or Arizona, Pennsylvania, Georgia. I'm aware of, obviously, Georgia, that there was a case brought against those individuals, but as far as specifics, no.
In that case in Georgia was well after December 14th, 2020, right?
Yes,
You've investigated fraud crimes before,
yes,
and forgery crimes before, right?
yes,
And these cases are typically financial in nature.
yes. Whether it's identity theft or check fraud, or maybe title fraud.
So, my point is that in your investigation, Ms. Shawn's not a lawyer, right?
To my knowledge,
Your
no, I
investigation-
found no evidence of her being an attorney.
So, would you agree that her posting publicly, candidly, what they did at the time, the day that this happened, indicates a complete lack of criminal intent?
Objection, Your Honor, speculation. Your question was which,
I'll ask it better.
okay, are you good?
I'll strike the question, strike the whole question, sorry. In your investigation, I'm sure you come across people who commit a crime and then they're trying to cover their tracks.
Yes.
Ms. Shawn's tweet that day was, do you agree, was in an effort to be, was indicating her belief in the legitimacy of what they did?
Again, objection, Your Honor, calls for speculation.
How was he supposed to answer that question?
So it's a specific intent crime, so he can say that whether or not what she posted on Twitter at the time.
Would cause him to believe that she had specific intent?
Yeah, or the lack thereof.
I'll allow him to answer, objective.
So, there was many posts that she had on that day, Twitter, Facebook. Would I agree with you that specific word would not support intent? Yes, but other statements did support intent that I found on statements about voting or I mean there's a whole host of social media posts, videos, and stuff like that about casting their votes and sending them to DC.
Made by this defendant?
Yes.
None of her votes, none of her statements in your investigation ever acknowledged that she believed she was doing something illegal.
No.
She never said she was trying to cheat anyone.
Again, I would have to refer to the Instagram or the Facebook, Twitter post. I don't recall hearing the word cheat.
Do you recall watching an interview on the show Crossroads?
Yes.
And what did you learn from that interview? What did you learn in that interview about? How did it further your investigation?
So, I can provide just a quick summary based on my recollection without pointing to the notes on my report. I believe it was with Ms. Maddock and Mrs. Sheridan and with a television host, and they said that they cast their votes, they cast their votes, and they were sending them to DC.
Yes. And isn't it true that Mrs. Maddock articulated her belief that they were following both U.S. constitutional law and Michigan statutes by attempting to submit their ballots?
Yes.
And in that same interview, Mrs. Maddock called for investigations into the election irregularities and expressed concern overall for the integrity of elections in Michigan.
That part I don't recall. I would have to view the video or report.
I have no further questions.
Thank you. Thank you.
Good morning, Mr. Shaw.
Good morning, Mr. Kennedy.
I'm going to just ask you a quick few questions about Give Fund Go, because I wasn't going to do that, but since Mr. Sundberg did. So you said during his questions that your focus was on statements that were made on that platform, right?
Yes.
And that you were trying to determine ownership of the pages or something like that?
Yes.
You're aware it's expensive to defend yourself in a criminal case?
Yes,
You're aware lawyers charge fees,
yes,
and those fees can mount up.
yes,
And we're at a preliminary exam stage of this, and it's already been countless hours spent defending this case.
yes,
Are you aware, perhaps that was not your intent, are you aware that your search warrant caused the defendant's ability to raise funds to significantly diminish and curtail? Are you aware of that?
I was not.
That wasn't your intent, though.
No, sir.
Okay, let's talk first about Mr. Jim Renner's testimony here in court. You were here that day, correct?
Yes,
All right, and so he told, by the way, did you review his transcript prior to coming today?
no, I have not received
Okay,
it.
but you were here,
Yes, sir.
and you heard him and you saw him on the witness stand.
Yes,
Do you recall him telling us that he was been involved with the Clinton County Republican Party for about 10 years?
Yeah, I'm going to object. It's not proper to ask the witness to comment on the testimony of another witness.
Your Honor, this is the lead investigator of this case. He has interviewed Mr. Renner, he has heard him testify in open court. I'm going to explore the testimony, his interview of him, how it impacted his decisions. He has testified here today that he on almost a daily basis is monitoring the wires, he continues his investigation. And so anything that's going on in this case is ongoing investigation that this man is continuing to do and is proper for this court to hear in making its bind-over decision.
Well, he's been questioned by another attorney about Mr. Renner's testimony.
Yeah, I objected to that too.
I think as it relates to their question, it's appropriate. I mean, obviously he can't just give opinions about another witness's testimony, but if he's trying to elicit a question about how that relates to his investigation, that would be relevant. So it's overruled.
Thank you, Your Honor. So he's been involved in Republican politics for about 10 years.
yes,
And that, do you remember him telling us how he got to be there on December 14, 2020?
yes,
And that's because Janelle Leonard called him?
yes,
And he got a very short notice about showing up, correct?
yes,
Maybe a day or two prior?
yes,
And he's one of these we call the two replacement electors, right?
yes,
He was not one of the original 16 who were elected to be Republican electors at the Republican State Convention back in August of 2020, right?
yes,
But the other people, including Kathy Burton, was elected on that day, correct?
elected on which day? The August convention?
That's right.
Yes,
This is, I can show it to you if you want. This is Defense Exhibit A, which has already been admitted, certificate of the Republican presidential electors elected at the Michigan Republican State Convention, August 29 to 30th, 2020.
yes,
Okay, you're aware Kathy Burton was elected on that day as a Republican elector.
yes,
And do you know who Janelle Leonard is?
the wife of Tom Leonard.
And do you know who Tom Leonard is?
I've heard the name.
Former Speaker of the Michigan House?
Yes,
So if Ms. Leonard called and asked Mr. Renner to be there, you're aware from your investigation that Kathy Burton has no involvement in Mr. Renner being there on that day on December 14, 2020, is that right?
I have not found any evidence of that.
Are you aware, both in his testimony and when you interviewed him, that Mr. Renner said he had no reservations about agreeing to attend the meeting on December 14, 2020?
I would have to refer to my report about his reservations.
Okay, that's fine. And he had no knowledge, real knowledge about the presidential electoral process and how it worked before showing up on that day, right?
Yes,
Do you have any evidence to suggest that Kathy Burton knew anything about the presidential electoral process before December 14, 2020?
I do know that she was involved in politics leading up to that. Specifically, what her knowledge or intimate knowledge is, no.
Okay,
I didn't get a chance to interview her, so I don't know. We didn't talk about that.
sure, but in your entire investigation dating back to December of 2022, I understand she was involved in Republican politics. My question is more specific.
Okay.
Did your investigation uncover any evidence that she knew anything about the presidential electoral process prior to showing up on December 14, 2020?
No.
Other than being asked by Stu Foster to show up a couple of days prior, to show up on December 14, 2020, do you have any knowledge that she knew anything about what she was walking into when she arrived at the MRP headquarters on December 14, 2020, just before noon?
No.
Do you recall
Can I back up for a second?
Yeah, I tell you what, you may have, if Ms. Logan or Ms. Greeno has some follow-up, they can do that on video.
Okay.
Do you recall a text message between Troy Hudson and Stu Foster where, remember, Troy Hudson and Stu Foster are both with MRP, right?
Yes.
Okay, they work under Laura Cox?
Yes.
Okay, and you're aware that they were the ones that were involved in getting these individuals to the MRP headquarters on December 14, 2020, right?
Yes.
And Stu Foster was the one that called Ms. Burton, right?
Yes, but Mrs. Burton had received, well, there was an email that was sent out by Mr. Chesborough leading up to this.
Yeah, we'll get to that, but since you brought it up, let's talk about it right now. Mr. Chesborough sent her an email prior to December 14, 2020, right?
Yes.
And when I say her, that's Ms. Burton.
Yes.
She never responded to that email.
I found no evidence of that.
Well, somebody else responded.
Yes.
Right? But Ms. Burton never did.
Right, Mrs. Sheridan.
Okay. But Ms. Burton did not.
That's correct.
Okay, so, and you know from your investigation that not only did Ms. Burton not respond to that email, but Ms. Burton had no contact whatsoever, phone, text, voicemail, anything with Mr. Chesborough. He told you that, right?
Yes.
So back to this text message. So again, these are the people that are involved. And when Troy Hudson is telling his subordinate Stu Foster to get these people there on December 14, 2020, do you remember that Mr. Hudson told Mr. Foster, quote, "Don't say sign a document, just say meet ahead of time," close quote. Do you recall that text?
Yes, I do.
Okay, because I have it here, but
I
do you
do.
remember?
I do
All right.
recall that.
So, so you don't have any evidence to suggest then that Ms. Burton was informed she'd be signing any documents at this meeting prior to her arrival on that day, right?
I don't have, focus on the text for a second. I recall the text. I don't remember who that exchange was between.
Sure. I can show it to you, but it's between Troy Hudson and Stu Foster.
Okay. I knew it was Stu Foster. I didn't know who the other person was.
Would you like to see it?
I'm all set.
Okay. But you remember it, you've testified.
Yes.
Okay. And so, not only don't you have any evidence, but we know specifically that there was a direction not to tell Ms. Burton that she'd be signing a document on that day. Fair?
There was a text message that said, don't tell anybody about signing a document.
Fair enough. Okay. Mr. Renner testified that the purpose of the December 14, 2020 meeting was to develop an alternate slate of Republican candidates / electors. Do you remember that?
I don't. I'd have to refer to his statement.
All right. Do you remember him telling us that his understanding was that there were two purposes for the document that he signed on that day? Do you remember that?
I don't.
All right, let's see if I can tell you what he said and see if you recall it.
Okay.
His first purpose was to present the Republican votes alongside the Democratic votes in Michigan Senate at 2 p.m. on that same day. Do you remember that being essentially his purpose number one?
Yes.
And the second purpose was to be a placeholder in the event former President Trump won a recount or some other challenge that resulted in Trump winning in Michigan. Right?
Yes.
And he said, in that event, the electors wouldn't have to come back and meet again if that were to happen. you remember that?
I don't remember that part.
Okay, but essentially you remember those two purposes I articulated. Okay. Do you remember Mr. Renner explaining, I would say his first purpose, purpose number one, that essentially just went away and disappeared when the people that walked over to the state capitol at 2 p.m. were denied entry by Lieutenant Green.
Yes.
Okay, so his purpose number one, gone when they weren't allowed into the capitol. Fair?
That's what he said.
Okay. And just as an aside, you're aware that Kathy was not at the Capitol building at 2 p.m. on December 14, 2020, right?
I did not have any evidence of that.
She went home with her sick and dying husband directly from the Michigan Republican Party headquarters. You're aware of that from your investigation, correct?
I have received statements that suggest that that may have happened, but I didn't have anybody in a car with her, traveling with her, so I did not interview anybody with that. So that's maybe what some people say, but I don't have any evidence to, you know, where an eyewitness says I rode in a car with her, we went directly home.
Well, her husband since passed, so it's kind of hard to ask him.
And I'm deeply sorry for that.
You watched the video that was introduced by the prosecution team in this case outside the Capitol building, correct?
Yes.
Did you see Ms. Burton in that video?
No, I said that just a moment ago. I didn't have any evidence of her being in that video.
Yeah, but I'm asking you a specific question. You watched the video and you did not see Ms. Burton in that video.
That's correct.
That video captured who was present outside of the Capitol building at 2 p.m. or slightly before 2 p.m. on December 14, 2020, did it not?
Well, it captured the people that were within the camera's view. So there may have been people standing outside of the view that it did not capture.
Okay, maybe she was hiding in the bushes?
I'm not saying that, Mr. Janine.
All right. On the second purpose, do you agree that Mr. Renner's testimony makes it clear that that is a contingency event?
Yes, Mr. Renner did say that.
Basically, something had to happen after December 14, 2020, but before January 6, 2021, correct?
I don't remember that part, him specifically stating that.
I'm asking you specifically, isn't it fair that something would have had to happen? Trump would have had to have, and we'll get into some of the testimony, but Trump would have had to have flipped the state of Michigan between December 14, 2020 and January 6, 2021 in order for this certificate, this alternate Republican certificate of votes to have any legal consequence or significance.
I can't answer that.
We'll get to it. All right, and Mr. Renner said you got there just a little before noon, is that right? Remember that?
That sounds right.
And when I say there, December 14, 2020 at the MRP headquarters?
Yes,
And you're aware that's around the same time Kathy Burton arrived?
I'm not aware of that.
Okay. Do you have anything in your investigation to suggest you got there any earlier?
There may have been. I just don't recall what time she got there.
And he too wasn't told anything about signing documents prior to the meeting?
He too, are you?
He too,
referring-
Mr. Renner.
Mr. Renner. I would have to look at the report to know what he was told, by Mrs. Janelle, or by Mrs. Leonard.
And do you recall him testifying he had no knowledge of how Ms. Burton became the chairperson, or whether that was something that was selected at random? Do you remember that?
I do not. I do remember that one of the witnesses had indicated there was a voice vote.
So basically, at the meeting on December 14, 2020, sometime afternoon is when she was named or voice voted as the chairperson.
Yes.
Does your investigation suggest she had any advance knowledge that she would be named by voice vote as the chairperson?
It does a little bit based on the information that I received from Mr. Chesbrough. And Mr. Chesbro had an Excel spreadsheet with the electors' names and contact information. And I believe Mrs. Burden had something labeled next to her name that might indicate that, but I would have to refer to those notes.
Okay, we'll take a look at that too later, but basically, I know what you're talking about. Mr. Chesbro didn't know Ms. Burden from the man in the moon, right, before this?
Yes, that's true.
He was provided a list of the 16 electors in the state of Michigan,
Yes.
just like he was provided the names of the electors in the other 6 states.
Yes, and that came from the Michigan GOP.
Yeah.
So they would have had that information, they provided it through the channels, but that information signifying her designation would have been on there going up through those channels.
Right, and all that did was identify what her role was within the Republican Party prior to this date. Is that fair?
Yes.
It had nothing to do with chairperson.
Again, like I mentioned, I would have to look at that specific document to determine what it said.
Okay, and just, I don't have it here, but for the record, because I know what you're talking about, Mr. Chesbro got an email with the names of the Republican electors from Michigan in a spreadsheet, correct?
Yes.
That spreadsheet had 16 names, right?
Yes.
And it had, if they had a title essentially associated with them, it had their title.
Yes.
And she was the Republican National Committee woman, right?
Again, I
We'll
would
look
have
at
to.
it, okay, fair enough.
If you want to put that on the record, you know, I would have to look at it in order to give you an honest answer.
That's fine, but, sir, this is your investigation, right?
Yes.
You've been at this since December of 2022?
Yes.
You've been doing this 70% of your time, I believe, 60 to 70% of your time since then?
Yes.
And I remember the document.
There's thousands of pages, but you have to keep in mind, you're focused on one client. I have 16 defendants and all the documents that are associated with those. So the amount of information you're focusing on is specific and relevant to your client. Mine is much broader.
Yeah, but I got all the stuff you gave us.
I believe you.
All right. So, I just want to be clear, as you sit here today, you have no memory that that document that you're talking about, that Mr. Chesbro had, that identified her as one of the 16 electors, that identified her as the chairperson. Or you're saying you just got to look at it?
I just say that I have to look at it. There was a designation there. I just don't know. I took an oath when I got up here, so
You know
I want to make sure that I'm honest and I'm accurate.
All right. That's good. Okay. Okay. Back to Mr. Renner briefly. He also testified here in court that these alternate certificate of vote should be used only if, quote, Trump was determined to have legally won the election, close quote. You remember that?
Yes.
And if former President Trump had somehow legally won the election between December 14, 2020 and January 6, 2021, in your opinion, would the alternate Republican certificate of votes have been a properly signed document on December 14, 2020?
I'm not able to make that determination.
Well, sir, I'm gonna ask that you make that determination. I'm asking you that there is plenty of evidence in your investigation that this was a contingent document. My question was, if the contingency came through, okay, I understand it didn't, but had the contingency come through, something happened between December 14, 2020 and January 6, 2021, would this document have been a properly signed document in your opinion?
So there's a number of different lawyers' opinions on this matter that I've come across in my investigation. Some say yes, some say no. In fact, Ms. Land, when I had interviewed Ms. Land about whether or not, why didn't she appear there, was because she didn't feel that it, would carry any weight. There was no purpose of doing that. Several people that I met or interviewed made that determination that there, even if there was something that occurred in the courts, that it necessarily wouldn't change things. There was a number of different scenarios that could possibly play out. So that's why I can't answer your question, because again, we have attorneys that had a difficult time coming up with a decision on that and arguing amongst each other, those even on the Trump team.
And that's all fair. So just to restate that a little bit, so people were debating this very question I asked you, right?
Yes,
Legal scholars came out on either side of that question, fair?
yes,
Some said yes, it mattered, and some said no, it wouldn't have mattered,
right.
fair?
Yes,
And you investigated those differing opinions.
and that's just what they were, opinions.
Right.
Because there wasn't any event that took place to change all that. So what we're proposing is, well, should-haves, would-haves, could-haves. I can't speak on that. I was called upon to investigate the information that I had in front of me and followed that along, but, you know, a number of different outcomes. You're asking me specifically to make a determination on that, and I don't have the ability to determine that. I don't have the, what I do know is that the document was created, the document was signed, the document was mailed, there was no recount. On December 14th, I was not aware of any court action. I was aware of, you know, the Speaker of the House, Lee Chatfield, Mike Shirkey, had said that there was nothing that was going to change the outcome of the election, and I'm paraphrasing here, of course. So that's what I was aware of.
Okay, but sir, you know, you tried to, and I don't say this disparagingly, but you tried to minimize your role here. You're just the guy that's developing the facts, right?
I'm not minimizing my role.
Okay, you develop.
I take my role very seriously.
You develop the facts, right?
I don't develop them. I gather them.
Fair. You gather the facts, and you presented a lot of that information, or I say some of that information in affidavit, right?
Yes,
And that affidavit, you swore to under oath, fair?
yes,
And you said, and we'll get into it a little bit, you said that somebody on the AG team drafted at least a portion of that document, right?
and we're talking about the affidavit
In
for
support
the
of charges.
charges. Okay, yes,
I mean, specifically, you said, you drafted paragraphs 1 to 37, right?
yes,
And somebody on the team over here drafted paragraphs 38 to 45.
yes.
And I guess while I'm doing it, did anybody provide you with edits to paragraphs 1 to 37?
I don't recall.
Did your boss on the criminal investigations division side do it?
I don't recall.
Did any of the prosecutors do that?
I don't recall.
If they did you have incorporated their edits if you agreed with them?
Yes, I'm the one that's swearing to it.
Sure. So you got it, I mean, so even paragraphs 38 to 45, you had to agree with, right?
Right, I'm swearing to it.
Right. And all the legal research you did, because there's a lot of legal research that went into paragraphs 1 to 37. You're citing statutes, you're doing some other things. That's all you. That's your testimony?
Yes,
Okay, sir, we went off on a little bit of a tangent, but I'm going to come back to my question. You've told us about other people's opinions. You've talked to us about differing opinions on the question that I posed. But I want you to answer my question. Do you need me to restate it?
yes,
Had Trump, former President Trump, legally won the election between December 14, 2020 and January 6, 2021, okay? Whether that's a recount, whether that's some court case, whether that's the state legislature doing anything, whether Congress did something, if that happened, would the document that was signed, People's Exhibit 14, be a proper document?
Objection,
No.
Your Honor. Asked and answered.
Not answered, Your Honor.
It was answered, if you didn't like the answer, but it was asked and answered. It causes for speculation and it causes for a legal conclusion.
I agree that it does cause for legal conclusion. I also believe he answered the question because he said he wasn't position, he answered that question, and that's an answer. So
All right.
that's the objection is sustained.
Now, when you swore out your affidavit, you write in there that the alternate electors, quote, knew prior to their meeting on December 14, 2020, there was no legal reason to create an alternate slate of electors, close quote. Do you recall writing that in your affidavit?
Yes.
You just testified that certain legal scholars and lawyers believe there was a legal reason to do that exact thing, correct?
Yes.
Now, when Ms. Chartier asked you to rattle off any other lawyers that you would call being part of this case, the very first person you talked about was Sean Flynn. Remember that?
Yes.
Do you remember that Mr. Renner testified that Sean Flynn was present on December 14, 2020, and appeared to be the one that was kind of running the show?
Yes.
Have you charged Sean Flynn?
No.
Have you interviewed Sean Flynn?
No.
Now, we talked about this a little bit, just got a couple other questions about it, that Mr. Renner testified that some of the people were gonna present the documents at 2 o'clock at the Capitol, right?
Yes.
And you're aware that there's a state law requirement about when the vote is supposed to happen of electors?
Yes.
And that's, again, a state law requirement, not a federal requirement, correct?
Yes.
You're aware in 1960 Hawaii, both the Democrats and the Republicans met together to cast their respective votes?
Yes.
But in 2020 in Michigan, the Republican alternate electors were denied entry. We talked about that, Lieutenant Green, correct?
Yes. The 1960 event was different than the 2020 Michigan event.
Okay, we're gonna talk about 1960 Hawaii since you just brought that up, but let me get through a couple more things first. Now, clearly the 16 Democrat electors who were in the Senate chamber at 2 p.m., they knew that they had just voted, right?
Yes.
What evidence do you have that Kathy Burton intended to lead anyone to believe that the document at issue somehow negated the Democrats' certificate of votes?
None.
Mr. Renner testified that there was no plot to defraud anyone, right?
I'd have to, again, refer to his report to cover that specific statement.
And in this courtroom, when he testified, he was crystal clear that if there was any such plot, he would have never participated. Fair?
I do remember that, yes.
And he was equally clear that he made no agreement with anyone, no agreement with anyone to commit a crime. Remember that?
Yes.
Mr. Renner's perception of the events on December 14th, 2020, based on his observations of everyone there, was that it was entirely legitimate. Do you remember him saying that?
I do not.
All right, let's take a look at that. I think that's
Okay.
Okay, I'm gonna go ahead and, I'm just gonna read it.
Okay.
See if you recollect it, and if you don't, then I'll hand it up to you. This is Mr. Renner, testimony on page 52, lines 6 through 12. My background is enforcing the law, not breaking the law. I brought my family up that way, and we respect the law. So to the extent that I knowingly had been told, first of all, that this was a questionable process, I would have raised my hand and said, let's discuss that a little bit more. But the actual opposite occurred. Would you like to see this?
No, I remember that, yes.
And Mr. Renner considered the election fraud allegations, he specifically referenced the allegations at the TCF Center, to be, quote, very serious issues that had not been addressed, close quote, as of December 14, 2020. Do you remember that?
Your Honor, at this time, I'm gonna remove my objection. We're basically going over the entirety of Renner's testimony before this court, which I believe the court remembers what he testified to. There's no reason to go through it again with this witness. It's not part of the investigation.
I think it's gonna be a scenic route, but I think we're going somewhere. Am I wrong, Mr. Danini?
You're not wrong, we're going somewhere.
Because there's no other reason why he would rehash when we were all present for that.
That's what's been happening, Your Honor. That's why we're doing my objection.
I think he's trying to align, I guess, the testimony from Mr. Renner to what your witness yielded from his investigation, what I'm assuming is happening.
Yes, sir.
Thank you, Your Honor.
So the objection is still overruled.
All right, so let's just summarize it. His two main takeaways from the December 14, 2020 meeting were that the process was legitimate and this was not a questionable process. Do you recall that?
Yes, that was his takeaway.
And Mr. Renner testified that while Ms. Burden and Ms. Rodriguez appeared to be running the meeting because of their titles, that people behind them seemed to be telling them what to do and say, and that's Sean Flynn specifically, right?
Yes.
And Mr. Flynn is the Trump lawyer, part of the Trump campaign, who ran this, I'll call it second, unsanctioned by the MRP meeting. Do you know, is that fair? Or you tell me what Mr. Flynn was doing that day.
Could you repeat the question?
Yeah, okay, and so, let's try to do it quickly. Laura Cox, head of MRP, right?
Yes.
You heard her testify.
Yes.
She wanted to have a meeting which she described as a ceremonial meeting. Right?
Yes.
And to sign the document that Ms. Burden signed and had notarized. We're gonna get to it a little bit later, but you know what I'm talking
To
about?
sign a document, yes.
And have it notarized?
There is a notary, or a space for a notary on it.
Okay. And then that meeting kind of starts and finishes, and then there's at least a continuation or a second meeting that Mr. Flynn kind of takes over. But at least that's how I view the events that day.
If, looking at the information, if it was a matter of Mrs. Burden signing just that document, then why are 15 other people coming there? So,
I can tell you one thing, Ms. Burden has no idea.
well,
Move to strike that comment, Your Honor.
Strike it.
I'm sorry.
You can
There was a motion to strike.
Oh, okay. Lost my train of thought now.
Sorry.
That's, anyways.
My fault. Go ahead, if you can remember, otherwise I'll keep.
I go ahead. I don't.
Well, on that day, okay, December 14, 2020, starting at noon and ending whatever it was, I think we had multiple people testify. Maybe it's 45 minutes, maybe it's an hour, maybe it's an hour 15. Is that about the range?
Yes.
Okay. Do you agree that there was a meeting that the MRP had envisioned for that day? Through Laura Cox.
Yes.
And that's, at least part of that was the signing of Defense Exhibit B, which is the, and I'll give it to you, but the one that Kathy Burden signed and notarized.
Familiar with it, yes.
Okay. And then there's almost a shift, and the Trump campaign takes over through Sean Flynn, and then People's Exhibit 14, at least the signature page gets signed that day.
There was one person that I interviewed that stated that. I
Who
believe
was
it
that? Sorry. Who was that? I'm sorry. You were going there and I interrupted.
I believe it was Troy Hudson said that. All the other people that I had interviewed did not say that.
How about Tony Zan?
Tony Zammit was aware that there was a document, but he did not get into the specifics that Troy Hudson did. You're talking about the fact that Sean Flynn took over. Troy Hudson was the only person that I interviewed that stated.
Because he was there, right?
He was one of a few people that were there, but he was the only one to suggest that.
And his testimony that he suggested was that he up and left because the MRP meeting was over.
Yes.
And that's when Sean Flynn took over.
Yes.
To your knowledge, no, sure. And we know from your investigation, your emails and whatever else, that Sean Flynn took possession of the plaintiff's exhibit or People's Exhibit 14, and he was the one that mailed it out the next day, correct?
When you say People's Exhibit 14, refresh my memory.
Sorry, the offensive document in this case, the
Yeah,
public
yes,
and
he-
alternate certificate of votes.
The interviews that I did, Tony Zammit had indicated that he saw Sean Flynn with those documents. That was the last person that he saw with those documents.
All right, and we'll get to it a little later, but let's do it now. On December 15, 2020, you have evidence that Sean Flynn was the individual who mailed those documents from the East Lansing Post Office. Isn't that correct?
I have evidence. I don't have evidence to say that for certain. Okay, I have evidence to suggest, and what I mean by that is he corresponds, or in some manner, to Mrs. Burden, asking her for permission to use her address to mail out the document. And there's an email exchange between him and there's a few people on the email exchange basically indicating that he had a conversation with her. He has permission to use her address on the document. We talked about when the postal inspector was up here, what information that we had available to us during that time as well. So do I have a witness or physical evidence that says that Sean Flynn was in a specific post office at a specific time, paying in a specific manner? I do not.
Okay. All right, we'll get to it. I think you do.
Okay.
And your testimony is almost right, but let me clarify real quick. Sean Flynn connected through Stu Foster to get to Ms. Burton. Is that fair?
I don't recall.
All right, we'll look at it.
Okay.
Okay. All right. Your Honor, just making you aware, I'm moving to a new subject. I don't know whether you want a break. I'm happy to keep going. I just wanted to let you know I'm going to transition forward.
Continue.
Thank you. Okay, I want to focus a little bit on some of the litigation that was ongoing during the time frame.
Okay.
And I remember you saying on cross-examination in response to Ms. Chartier that you said, she asked you about cases that were going on at the time. I wrote down that you said, quote, "For me to look at every single court case across the nation would be quite difficult," close quote. Do you remember saying that?
Yes.
So you testified that this is 60 to 70% of your daily job, right?
Yes.
If it's difficult for you, do you think it's difficult for a former farmer, retiree, who doesn't have a law degree to know what's going on with court cases across the country or in the state of Michigan?
I couldn't answer that.
You couldn't answer that.
No, I don't know what resources that she has available to her. Being connected with the Michigan GOP as a candidate for elector, and what sort of relationships she has with them, because now you're talking about a number of different resources that I don't have. So I can't, that's why I can't answer that. So it's not, I'm not being disrespectful to your client.
No, you know that even though she has a title, she's a volunteer. You're aware of that?
I understand that.
She's not paid for being on part of the Republican Party. You're aware of that, right?
Yes,
She shows up for some meetings sometimes, and that's about it.
I don't know, I can't answer that, what she does,
You didn't investigate that?
not specifically like what her daily activities were, no.
Well, you seem to be focused on the fact that she's the chairperson, she's the national committee person. Don't you look into those things?
I look into matters that are directly going to support evidence that would support the elements of the crime.
I suggest to you that you should also look at things that don't support the evidence. Oh, great. Anyway, so you were generally aware of litigation surrounding the 2020 presidential election, correct?
Could you repeat that again?
Yeah, you were aware that there
I was
was-
caught up on your last sarcastic remark, so I didn't.
Yeah. And it was, and you should.
Who's
So-
described, Your Honor?
So what's,
What was the question?
Never mind, it's withdrawn. You're aware of litigation involving the 2020 presidential election, right?
yes.
Were you keeping tabs on it?
So you have to remember, I investigated this after this litigation took place. So I looked into litigation that was taking place at the time and looking through court records and things like that. So does that answer your question?
It does. So basically what you're saying is you weren't focused on it in December of 2020, but you certainly were after December of 2022.
Yes.
And what kind of allegations do you remember seeing in your investigation of those cases? Do you remember any of them?
I remember there was allegations of voter fraud and irregularities.
Now, there are a number of cases that were filed in the state of Michigan. I just want to know if you recall looking at any of these that I'm about to go through. Constantino versus the city of Detroit.
I would have to refer to my notes.
I've got them here, we can take a look. But so you mentioned at least some of the things. Let me tell you and see if they resonate, the things you heard about. In that case, there were allegations of forged ballots. Did you ever hear any allegations like that?
I would have to refer to my.
Illegal voter coaching. Did you ever hear that?
I'd have to refer to my notes.
Changing dates on ballots so that they'd be counted when they shouldn't have been counted.
I'd have to refer to my notes.
Illegal double voting by certain individuals.
I'd have to refer to my notes.
Out-of-state vehicles dropping ballots off in the middle of the night. Did you hear any allegations like that?
I do remember that, yes.
The lack of transparency in the ballot counting process. Remember that?
I'd have to refer to my notes.
Remember there were some allegations they kind of put a big board over the windows and people couldn't look in?
Oh, that's what, yeah, I remember that.
people not having access to something called the qualified voter file.
Yes, I remember that.
Do you know what the qualified voter file is?
I'd have to refer to my notes on that.
Okay, I mean, it's basically, if this refreshes, do you recall the qualified voter file being a list of essentially people's information and signature, and then that's something that the actual votes could be married up against?
That sounds about right.
And signature issues on absentee ballots? Do you recall
I'd
that?
have to refer to my notes on that.
And chain of custody issues, I think there were some allegations about that. Do you recall that?
Chain of custody issues with the votes?
With the votes, yeah.
I'd have to refer to my notes.
Let's take a look together at, are you aware that in the Constantino case and other cases too, that there were affidavits that were submitted to the court in conjunction with those complaints and allegations?
Some of the court cases I did look at, I don't remember specifically this Constantino case, but I do remember affidavits. And there was a lot of other supporting documentation when they filed with the court.
Okay, so your memory is that in connection with the court cases filed in the state of Michigan, there were affidavits and other supporting documentation in conjunction with the allegations.
I would, yes, but I wouldn't say specifically with the state of Michigan. I would say yes in general. I don't recall about the specific cases in the state of Michigan.
There was and I'm gonna ask you, I'm gonna read some of these, I'm only doing a little bit, but I wanna see if this, if you're aware of allegations like these. This is an example. So in the Constantino case, there was a gentleman by the name of Jesse Jacob that filed an affidavit. And he states,
Yeah, I'm going to object, because this sounds like hearsay.
well, it's gonna go well too often, but it's the effect on him. Does
Not
this?
being offered for the truth of the matter.
That's right.
Well, can we establish that the witness actually read this before we talk about the effect? Because if he hasn't read it, there is no effect.
I'll also the objection, but I do agree that you should establish that he's read, was familiar with the case.
Okay, well, Your Honor, okay. So, you said you reviewed a number of cases, right, in your investigation?
Yes, sir.
A number of them in the state of Michigan.
Yes.
Constantino versus the city of Detroit was one of those cases?
I don't recall. That's why I said I'd have to refer to my notes.
Sure, and I don't have your notes here, but there were a number of cases filed in the state of Michigan, and this was one of the significant ones that went up to the Michigan Supreme Court. You looked at a number of them, you just don't have a recollection of this one specifically.
Yes, sir.
Okay, and you said you did look at affidavits and other supporting documentation, right?
Throughout a number of different cases.
Okay. Do you recall reading the affidavit of Jesse Jacob?
I do not.
Okay. Could you have?
Could I? What?
Could that have been one of the affidavits and other supporting documentation in connection with these various cases that you could have reviewed?
I could have. I just don't recall.
Let's see if you remember what Mr. Jacob said.
And I'm gonna renew my objection, there's not enough foundation laid that this would have had an effect on this witness.
Your Honor, if I may,
And
What?
just respond. In fairness to the witness, he's reviewed a lot of stuff, and he has expressed over and over again his lack of recollection of specificity with respect to those things, because he's got a lot on his plate, and that's fair.
trying to refresh his recollection here, is that what you're gonna do?
Yeah,
Can it be shown to the witness instead of read into the record?
Yes, you can show it to him.
well, I want the court to be aware of what's in here too, though.
Well, we have to decide if it's gonna come in first. Here's the objection.
May I approach the witness, Your Honor?
Yes.
All right. I am handing the witness the the Jesse Jacob affidavit that was filed in connection with the Constantino versus City of Detroit case in the Wayne County Circuit Court, dated November 7, 2020. And I'd ask the witness to review this 19-paragraph affidavit, and you can pay attention to the highlight.
Okay. Yes, I vaguely remember reviewing this.
Can you speak a
So,
little louder?
I-
It's
I'm
a
sorry.
larger courtroom, so everyone just.
I
can hear what's
vaguely
said.
remember reviewing that at the beginning of the investigation.
Objections overruled.
Let the record reflect, I'm handing a copy of that affidavit to the Assistant Attorney General for review. For their review. While they're doing that, would you agree with me that affidavits are evidence?
Yes.
And they're, effectively, it's like a preview of what somebody might say if called to the stand like you're testifying today, fair?
Yes.
Now, and if you don't remember, that's okay. Are you aware that the Wayne County Circuit Judge in that case denied what's called adjunctive relief in this case on November 23rd, 2020?
Yes. That sounds familiar.
And that was the same day that the State Board of Canvassers met to certify the
Yes.
election. Do you remember that being that significant date too?
Yes.
And Mr. Van Langeveld was on that State Board of Canvassers and cast a vote in that direction. Do you remember that?
Yes.
Now, that case, while that decision happened on that day, are you aware that this case wasn't ultimately dismissed until January 8th, 2021?
I don't recall
Now, you said that your memory was refreshed, and I believe you did look at this Jesse Jacob affidavit, do I have that correct?
that. Yes.
As the lead investigator looking into these issues, and you know that there were at least allegations of voter fraud, right?
Yes.
Does it matter to you as the investigator if somebody who was working for the city of Detroit and assigned to the elections department for the 2020 election was instructed by his
Your Honor, I'm going to object again, and I know that the court has ruled effect on the listener, however, the testimony has developed that this case was dismissed in January of 2021, and Investigator Schock's investigation did not begin until December of 2022. There has been no foundation for effect on the listener for a dismissed voter challenge.
Where are we going with this line of questioning anyways?
Well, Your Honor, this witness is, again, the investigator who says that there was nothing going on, essentially, that could have changed things after December 14, 2020. And this is evidence of voter fraud, and I want to know if it mattered to him.
Okay, so your line of question is whether or not this case still pending had any effect on the decision that he made to offer the affidavit probable cause for the complaint. Is that your question? It's relevant?
It's the content of the affidavit, Your Honor. You can ask the question without reading the contents into the record.
Okay, I don't have to read it, but I have to paraphrase it.
No, you don't. He's
Yes.
read it.
He read it to make sure he had prior knowledge of what you were gonna ask him about. You don't need to put the contents of that into the record.
But, Your Honor, I think that one of the fundamental things here is we know today that there were no issues of fraud, voter fraud, that could have overturned the election. Fair?
Okay.
But there are at least some people that didn't believe that to be the case as of December 14, 2020. And so if there are these things out there in the public domain, which this was, it's a publicly filed document, that had allegations from real people, this one being a City of Detroit employee who worked for the elections division, who was instructed to do improper things. Those things, if believed to be true, and could have impacted the election between December 14, 2020 and January 6, 2021, are very much relevant to these proceedings.
May I?
You may.
In December 2022, when this investigation is taken over by Investigator Schock, we know what happened with this legislation. And to ask Investigator Schock, well, this was pending until 2021, could this have affected somebody who may have heard about it? That's speculation all on its face. We know what happened with that legislation, and ultimately, nothing happened with it. It was dismissed, it was unfounded, and to go back a year and 11 months and say, well, somebody might have thought this was legitimate, we can't do that. That's not how that works.
Well, I think his question is whether or not the fact that there were these allegations, did that affect, again, his decision. He's the one who authored the affidavit of probable cause under penalty of perjury that these people committed these crimes.
Oh, I'm okay with that question.
I think what he's asking is not for him to determine whether or not, you know, back then, the people possibly have heard, who are aware of it. I think we've already established that, our prior testimony, but whether or not that would have had an effect on the decision, the ultimate decision he made, I guess, to have this charging document issued, is what I believe is where we're going.
Right, and Your Honor,
Right.
with all due respect, we're exactly looking backwards. That's what we do in court cases. So Mr. Schock, while not assigned until December 22, is providing facts to a judge to authorize charges based on these people's intent as of December 14, 2020. So what they knew or didn't know on that date is 100% relevant to these
I agree
proceedings.
to that.
But my point, Your Honor, is whether or not that this case, Constantino versus the city of Detroit, was pending in December of 2020, this witness cannot say that any of the defendants was aware of it. I'm not objecting to the witness talking about the effect on this witness. I am objecting to the bootstrapping of saying that because this was pending, the defendants had a legitimate question about the election. This witness cannot testify.
We previously asked this witness if there was anything that could have, I guess, I'm paraphrasing now, legitimized this document that was filed. And so I think that's what the
People's Exhibit 14.
People's Exhibit 14.
Oh, and he said he didn't know.
Right, so I think that's what he's trying to establish, that maybe he did know. So it's also close to credibility.
So, as the investigator, looking back on the facts as they existed back on December 14, 2020, to attempt to establish specific intent, you agree that this is, that at least some of these offenses are specific intent crimes, right?
Yes,
That these people had to know they were doing something wrong, right?
yes,
Did it matter to you that there was a city of Detroit employee assigned to the elections department for the 2020 election, Mr. Jacob, that said he was instructed by his supervisor to adjust the mailing date of these absentee ballot packages to be dated earlier than they were actually sent? Did that matter to you?
yes.
Yeah, I thought we agreed that the witness could answer the question without this being read into the record.
We did agree to that, but at this point it's been read, and it doesn't really have much effect on the decisions I need to make. It really helps him answer this question, I suppose.
How did it matter?
He did answer,
How
that
did
it did matter.
How did it matter?
It's information that led me to an interview with Mike Shirkey and asking him, you know, what was his responsibility in all of this? What did he see? What did he hear? Was there? He referenced the McBoom report. Okay, so again, he told me that we didn't have it at December 14th. You know, there wasn't anything, you know, that was going to assist us in the courts or somehow change the direction of the election. It wasn't going to overturn it. So that's what led to that interview. And so, does that answer your question?
Well, but it inspires a few more. So, Senator Mike Shirkey, you interviewed him, right?
Yes.
And he said that he came to the conclusion that there were not sufficient allegations of voter fraud to overturn the election, right?
Yes.
And he came to that conclusion shortly before December 14, 2020, right?
Yes.
I mean, that's just one man's opinion, fair?
No, it's based on a lot of interactions that he had with whether, people. So whether they were attorneys or whether they were people in the party, that's it.
That's fair. You think Senator Mike Shirkey was more informed about the 2020 presidential election than Ms. Burton?
That causes for me to speculate. I don't know. Again, I didn't get a chance. I interviewed Mike Shirkey, right, and I didn't get a chance to interview your client, so I can't answer that.
He said he talked to lawyers and others and was very much following things, and his role as the Senate Majority Leader certainly caused him to be paying attention.
Yes.
Did you see in here where there were allegations of coaching voters to vote for Joe Biden?
Yes, I did see that.
Did that cause you to do anything in your investigation?
Just continuing to interview people and gather as much information as I could.
And Did it concern you that he alleges, that he states, that he saw election workers going into the voting booths with voters to watch them vote and coach them who to vote for?
Yes.
Did it concern you that he says that he was instructed not to look for any deficiency in the ballots that were cast?
Yes.
Did it concern you that he stated that he was instructed not to compare the signature on the absentee ballot with the signature that's on file in that qualified voter file system?
Yes.
Did it concern you that he said that he was instructed to improperly predate absentee ballots, their receipt date, that were not in the QBF, as if they had been received before November 3rd, 2020? Did that concern you?
Yes.
And he says that the reason to put it in the QBF was to falsely show that the absentee ballots had been received in time to be valid. Did that concern you?
Yes.
Sir, is it fair that if those allegations, and those are only some of the allegations that were floating around at the time, if some of those allegations were true and corroborated, and a court said that that could have impacted the election after December 14, 2020, isn't it possible that the state of Michigan could have flipped in favor of former President Trump?
That causes for speculation. I mean, anything's possible. I don't know, and I suppose that answers your question. Anything's possible.
Okay. It does. Thank you. All right. I'm not going to do a lot on these, but do you recall the case of King versus Whitmer
Yes.
and other allegations of voter fraud? Fair.
Yes.
And one of the allegations said that if there was a favorable resolution of the allegations of voter fraud, that the election could change from Biden to Trump. Did you remember that that was an allegation in the complaint?
I don't. I would have to look at the.
Fair. How about, this had allegations of computer systems being hacked. Do you remember anything about that?
I do, just vaguely. I don't remember specifics. Again, I would have to look at the material.
Okay. And this case, there was a cert petition filed to the Supreme Court of the United States on December 11, 2020, ultimately dismissed about a year later on December 21st, 2021. Were you aware of that?
I don't recall that. I would have to look at it again.
Just to state the obvious, if I'm correct, and it was still pending as of December 2021, then it was certainly pending on December 14, 2020. Fair.
Yeah, that makes sense.
How about Bailey versus Antrim County? You remember that?
Vaguely.
That was that whole software.
Are you talking about the
glitch.
tabulator?
Yeah, remember that?
I do.
And basically the allegations were there were a bunch of votes that came in for Trump that were in Biden's column. Do you remember that allegation?
Yes.
And that the software that was used in Antrim County was used in about half of the counties in the state of Michigan.
That part I don't recall.
Okay. And for that case, that issue, we know today, that didn't turn out to be substantiated, but that was what was going on at the time, fair?
Yes.
That case wasn't dismissed until May 18, 2021. Are you aware of that?
Again, I'd have to look at my notes.
Fair. How about Stoddard versus City Election Commission? You aware of that case?
I don't recall.
That's not the favor. Now, this one actually was over by December 14, 2020. Were you aware of that?
Which one?
Stoddard. Oh, you said you didn't remember.
I didn't remember.
Okay, fair.
Yeah.
How about cases outside of Michigan? Did you look at any of those?
The Texas one comes to mind. All the others, I don't recall.
How about the Wisconsin one, Trump v. Biden?
I vaguely remember looking at that, yes.
Okay. This one actually gets dismissed by the Wisconsin Supreme Court on December 14, 2020. Were you aware of that? I think there was a text message about that. Do you remember that? At 11 a.m. or so?
Yes, there was, well, no, not the Wisconsin one, I don't remember. I know Mrs. Burden had posted something about the Texas one being dismissed.
Okay.
And I can't, and it was before December 14th, when she posted that, but I don't remember what you're referring to, on the Wisconsin.
So Wisconsin one thing, Texas case, Texas versus Pennsylvania, right? The Texas case, which is called.
I think it was Texas.
And we'll get to it, but you said you knew that Ms. Burden posted about it, the decision, right?
The Texas case?
Yeah.
Yes,
Because you put that in your affidavit.
yes.
All right, we're gonna look at that later. Are you aware that Michigan was kind of involved in play, so to speak, in that Texas versus Pennsylvania case?
Yes. If we're talking about the same Texas case,
I think we are.
I mean, some of our defendants were listed on there as plaintiffs. Is that the case you're referring to?
Yeah.
Okay.
Not Ms. Burden.
No.
When I say not Ms. Burden was not a plaintiff in that case. Right?
Yes.
Okay. Let us take a look. Well, let me ask you, and then if you need to see it, I will show it to you. You say, you use that in your affidavit in support of the charges against Ms. Burden, right?
I'd have to look at that again. When you say you're using that, what are you referring to?
That is one of the facts that you included in your affidavit in support of the 8 felony charges being filed against Ms. Burden in this case.
Let me say it again. When you say that, what are you referring to though?
That is the fact that Ms. Burden was at least tangentially aware that the Supreme Court dismissed the Texas versus Pennsylvania case
yes.
on December 11, 2020.
Yes.
And specifically, in paragraph 34 of your affidavit, you state that Ms. Burden knew about the U.S. Supreme Court dismissal of that case on December 11, 2020, based on a post she made on social media about it, right?
Yes.
But you didn't stop there. You went on. Your affidavit goes on. And you made the leap of saying, prior to the meeting of the Republican candidates for elector, Mrs. Burden was aware the courts did not find evidence of voter fraud that supported overturning the presidential election. Close quote. Do you recall writing that?
I do vaguely.
May I approach, Your Honor?
Yes.
Oh,
It's an affidavit.
Yeah.
It's in front.
It's in file. So directing your attention to paragraph 34, that's what I read from. Please tell me if I read
you didn't give me
Sentence correct.
all of that.
Oh, I'm sorry. Oh, no, sorry. I'm wrong. I gave you wrong. My apologies. This is the one that didn't get printed properly. So what I handed you before was just part of your affidavit. My apologies.
I understand.
So go on to page 34. or paragraph 34, excuse me. 34. Oh. I'm asking him about what's in there. I'm changing this.
Court.
So did I read correctly the quote?
Yes.
Now, we just went through a bunch of cases, and at least my representation to you that a number of them were still pending after December 14, 2020, right?
Yes.
Okay. Don't you think it's a leap to say that one case is dismissed and that Ms. Burden is aware that the courts, that all courts, did not find evidence of voter fraud?
No, it's this specific one.
Just one?
That's what I wrote.
You wrote courts.
No. It's this specific court.
So you're saying that even though courts is plural, you meant to say this one court.
I didn't put the apostrophe in.
Ah, that's what it is? So it meant you were, you.
Courts meaning apostrophe specific to that court. So it's a grammatical error on my part.
Mrs. Burden was aware that the courts, apostrophe S, did not find evidence of voter fraud before overturning the president's election. Okay, do you think that the judge that reviewed, assume the judge read every word very dutifully, which I'm sure he or she did. Do you think that the judge knew that you meant apostrophe S?
Objection, speculation.
Well, Your Honor, this really goes to credibility. This is the person who is providing the facts to the magistrate judge who authorized charges in this case that you are deciding whether to bind over. And that magistrate judge, I suggest, was at least slightly misled by this use of a quote.
Well, I don't think he can testify as to what the magistrate believed when she read these affidavits, but you could question him about whether he believed that clerical error changed the meaning of his affidavit.
Do you believe that the clerical error that you just pointed out changes the meaning of your affidavit?
No, like I said, my writing here is specific to the court that she posted. So it doesn't change, does it change the meaning for me? No, it doesn't change the meaning. I'm not trying to make things up here. I'm not trying to suggest that there was multiple courts. I've laid out the court.
The question was, does it change the meaning for you, though?
Oh.
You weren't writing for your own purpose, you were writing for another purpose. And do you think that leaving that apostrophe, which there's a reason why there's supposed to be apostrophe?
Yes, understood.
Does that change the meaning of the language that you put in your affidavit?
I suppose somebody could interpret it as that.
Do you think it changes it?
No, I don't.
So if you read a document that states a plural, courts to me means more than one court. Do you agree with that?
Yes, but the magistrate also has the ability to give me a call or send me an email to seek clarification on it as well.
Did she, or is it a he or she?
It was a she.
Did she?
I don't recall, but if she would have, it would have been pointed out and addressed, just as we're talking about it right now.
But you have no memory that she did.
I do not. I do not recall.
And just from my perspective, if you read that sentence, and I want you to do it real quick, read that sentence with an apostrophe.
I just did.
Does it work?
Does it
Mrs.
work for-
Burden was aware that the courts, apostrophe S, did not find evidence of voter fraud.
Okay.
That's not possessive to the court. It just doesn't, what your testimony is doesn't make sense grammatically. Do you agree with that?
I would not.
So you think, in context, reading the word, that sentence with an apostrophe S makes grammatical sense to you,
That's my understanding, yes.
but that's your testimony.
Yes, that's why I'm telling you that's my understanding, yes.
All right, I'll retrieve that. Your Honor, I'm again moving to another area, so I know it's noon, I'm happy to keep going. Just want to know the court's pleasure.
It's just in between their lunch. I'm happy to keep going.
Okay. Okay, you testified oh, you know what? Just real quick, because I forgot to mention, I wrote it down, McBroom report, you mentioned that in conjunction with testimony about Mike Shirky. Remember?
Yes.
That McBroom report came out in like, I'm gonna guess here, June of 2021, that's like, yeah, certainly well after December 14, 2020, right?
Yes,
When was it, do you know?
I don't recall.
Does June 2021 sound about right?
It sounds about right, yeah.
And that's the document that really analyzed the allegations of voter fraud that were going on, right?
Yes.
And came to the conclusion that they were insufficient to overturn the election, fair?
Yeah, yes.
But that again was, let's call it 6 months after People's Exhibit 14 was signed.
Yes, but Mr. Shirky must have had some additional information prior to that document coming out, because like we just talked about, you know, he didn't feel that there was any evidence of voter fraud that would overturn the election before December 14th.
Do you have any evidence that Mike Shirky spoke with Kathy Burden prior to December 14, 2020?
I do not know.
Okay, you testified earlier about the fact that you reviewed the Ingham County prosecutor, Mr. Stevens' memo, correct?
Yes,
Okay. Are you aware that that memo was drafted essentially after analyzing the evidence and the facts of this case?
could you clarify that?
Sure.
So, because, you know, the timing of all of this, you know, by the time I took on the case in 22, late 22.
Yeah. So that's fair. But so you weren't, let's be fair, you were not involved in this case until December of 2022, right?
Yes, sir.
All right, so I'm asking about things that happened in March of 2021.
Okay.
And I'll see if you're aware. Are you aware that the Attorney General's office basically tried to shop this case to the Ingham County Prosecutor's office?
No, I'm not. I was aware of the fact that it was reviewed by the Ingham County Prosecutor's Office.
Are you aware that they reviewed it per a request from the Attorney General's office?
I'd have to go back in my notes if there was any sort of request in the, our records management system.
Let's get a little more specific. Are you aware that Assistant Attorney General Richard Cunningham asked Ingham County Chief Assistant Prosecutor Mike Chellingham to review this case back in March of 2021?
I don't recall that.
Are you aware that in that email that Mr. Cunningham sent to the Ingham County Prosecutor's Office that he said
Your
it
Honor, I'm
appeared
going
that a
to
forgery took
object
place?
to hearsay. The witness has already said he's not aware of the request by the Assistant Attorney General to the Ingham County Prosecutor to review it, and there's no causation link that he would be privy to this email, and even if he were, it's hearsay.
Objections.
That's fine, Your Honor. I'm gonna ask that I allow this witness to refresh his recollection on discovery that was provided in this case that he may have reviewed. And we'll see if he
What are
did.
you refreshing his recollection about?
I am refreshing his recollection whether he is aware that the Attorney General's office asked the Ingham County Prosecutor's Office to investigate the facts of this case.
Oh, this topic.
I don't believe he needs his memory refreshed. He said he wasn't aware of the request, not that he didn't recall.
Well, I'm asking him based on his investigation and documents in his investigative file that were produced in discovery in this case, whether he's reviewed the document. And perhaps, again, amongst thousands and thousands of documents that are in existence, he may have forgotten this particular one, and so I'm asking him to review it. And if it doesn't refresh his recollection, then I'll move on.
Was that just published to the court?
It doesn't even have an exhibit number on it. It's supposed to be an exhibit.
Well, not yet. So does that, let me ask, did you have an opportunity to review that document?
Let me review it.
Oh,
Hang on one second. I don't recall reviewing this document. I just want to make sure I don't see my name on it as well, so it was dated March of 21.
does reviewing that document refresh your memory at all about the topic of the Attorney General's office asking the Inland County Prosecutor's Office to investigate this case?
Again, I was aware that the Ingham County Prosecutor took a look at the case and reviewed it. Does that answer your question?
So I guess you just don't know how they came to review it.
No.
And that email doesn't refresh your memory that it was the AG's office that asked them.
I don't recall seeing any of that.
And that never came up in any of your discussions and your team meetings or anything about this APA Stevens memo?
No. That memo, no.
Do you have any knowledge about the Attorney General's office trying to get the U.S. Attorney's Office for the Western District of Michigan to investigate this case?
I don't.
Never heard of it?
No, I'm aware of it, but specifics? No, I don't have any knowledge of the specifics.
You are aware of what?
The fact that our office may have had some sort of communication with somebody on the federal side about this case. What that communication was, I don't know.
May have had or did have?
May have had,
How did you learn that?
probably from my boss.
And fair that there's no criminal case pending in the Western District of Michigan against Kathy Burton?
I'm not aware of it.
You mentioned a guy from the National Archives named David Stupar, right?
I didn't mention him
Oh,
today.
you
No, I mentioned to Mrs. Chartier that I had been in touch with the National Archives.
Was David Stupar one of the guys you were in touch with over there?
Yes.
When he found out that the case was with, at least being looked at by the U.S. Attorney's Office for the Western District of Michigan, did you know that he sent an email stating that he wanted to quote-unquote lobby
Objection,
for a
Your Honor.
prosecution?
Hearsay.
How is this not hearsay?
I want to know if he's aware of it and whether that
What is
impacted.
the purpose of being offered?
Because, well, I want to know how it is that people get to lobby for prosecutions.
I'm sorry, is that a legitimate purpose for this to be offered?
Look, Your Honor, this case, these facts were investigated by the Ingham County Prosecutor's Office, declined. The Western District of Michigan U.S. Attorney's Office, declined. There's pressure coming from Washington, D.C. through a request, which we have an email, where somebody in D.C. is lobbying for a prosecution. And then,
I'm not
many
disputing
years.
any of those things. The objection was hearsay. You said you're trying to figure out how people can lobby for prosecution. That's not a response to a hearsay objection.
It's the effect on this witness, Your Honor.
How can there be an effect if he's never seen the email?
I want to
Not
know.
aware.
I want to know if he's aware of anybody lobbying for prosecution in this case.
You can ask that. That's not hearsay. Objection sustained.
Are you aware of people lobbying for a prosecution of this case? Did David Stupar attempt to lobby for a prosecution?
No, not to me, he did not, and we never had any sort of conversation about that.
In your investigation, did you see the email dated Anyway, did you remember reviewing an email that David Supar sent saying he wanted to lobby for prosecution?
I don't recall seeing that.
All right, I'll move on. There's also in the discovery a letter from some civil attorney named Bradford Springer. Sent a letter on January 10th, 2023, before charges here, asking for.
Objection, Your Honor. Hearsay.
Well, I want to know if he answered.
Are you reading the email into the record first?
No.
It sounded like what you were supposed to do, though.
No, so, are you aware of somebody, a civil lawyer, who is gonna file a civil case based on these facts? His name happens to be Bradford Springer, asking the Attorney General's office for information about the electors so they could serve their complaint on these electors?
Not aware of that.
Did you coordinate your investigation with civil lawyers?
What do you mean by coordinate? I mean, when I reached out to interview your client, I received a call back from Mr. Warrington. Is that what you're referring to?
No, but that would be a criminal lawyer.
Yes. They do all types of practice law, but I'm not sure what you're asking me.
Did you in any way coordinate your investigation with civil lawyers who filed a civil complaint alleging similar things to this case? Did you coordinate your investigation with them?
No, I did not work with any civil attorneys.
Did you share information about these 16 electors with this civil lawyer?
No, I did not share any information.
Just for my clarification, civil lawyers where?
Yeah.
So there's a gentleman named Bradford Springer, I believe he's involved in, there's a civil lawsuit, essentially a parallel civil lawsuit. And in January of 2023.
Well, my question is, a civil, because when you say a civil lawyer, that'd be someone from the civil litigation department at the AG's office. I don't know what you mean.
That's fair.
specifically.
That's fair. What I'm trying to get at, sir, is we have a letter from a private civil lawyer
Okay.
who has filed a civil case against these same 16 individuals. Okay, let's stop there. Are you aware that there's a civil case?
In Kent County, is that the case you're referring to?
Yeah, yes.
Yeah, I'm aware of that case, but that was filed a long time ago.
Right. Probably around January 2023.
No, as I remember, it was in 2022. The case that I'm referring to, I think it was filed in 2022.
Okay. Are you aware that somebody involved in that case named Bradford Springer was contacting the Attorney General's office asking for information about these 16 electors, their address, contact information, things like that?
No.
And your testimony is you didn't share any information with private civil lawyers.
No.
Are you aware if anybody in the Attorney General's office shared any information in response to that letter?
Not aware.
Would you agree with me that the memo that Ingham County Prosecutor APA Stevens drafted essentially determined that
Objection, Your Honor. Hearsay.
You already sustained that as hearsay.
well, so, and I'm gonna ask the court if this is okay to do, I'm gonna ask a bunch of questions about statutory language, but there is some information that's in the memo that I think is helpful. And since this witness testified that he reviewed this memo, I believe he said prior to bringing the charges being brought here, although we'll clarify that. I wanna know if these things impacted his decision.
Well, I think you can ask them if that memo impacts the decision without getting into specifics of the memo. And getting into what was specifically stated in the memo is the hearsay issue. Not whether or not that memo in and of itself affected his decision.
But I think there's various aspects of the memo that I wanna get into and whether those things impacted his decision.
I don't know how you would do that without getting hearsay.
Because it's the effect on him. It's how does it impact him? He's the lead investigator. So I'll try to, well, why don't we do it one question at a time?
Okay.
Your Honor, may I just join in as a response to Mr. Danini? The other impact would be Agent Schock said he's the one who actually did research on statutes, both federal and state. And so if there are statutes where there's a contrary conclusion in the Ingham County Prosecutor's memo, I agree with Mr. Danini, that does go to the effect on Mr. Agent Schock.
I can understand that, but if he's asking about whether or not this agent was aware of statutes, that's one question. He's asking about a memo, which this agent is not, he's testified he wasn't really aware about the memo, he didn't read the memo.
No, I don't think so, Your Honor. I think I'll ask him that question. I think
Yeah.
Did you read the A.K. Stevens memo?
Yes, sir.
Oh,
And did you read it before your affidavit that authorized charges in this case?
Yes.
so you wanna ask him as to whether or not the statutes referenced in that memo affected his decision?
Yeah, but I'm gonna do it in some.
I know you wanna take the scenic route.
Yeah.
Objection overruled.
Thank you. Okay, let's take a look at the statutes a little closer here. And we've spent a little time on it, I think we need to dive into it. Forgery is one of the charges you've authorized, well, that your affidavit authorizes here, right?
Yes.
And you testified that you did research about the forgery statute.
Just what's printed on the affidavit there.
So you just copied and pasted the forgery statute into your
No,
affidavit?
I mean, the MCL number. Perhaps I didn't explain it good enough. So just read the statute.
Okay, you read any cases about the statute?
I think it printed like cases that have been, I don't know what you're asking.
Are you talking about case law?
No, I didn't read any cases.
I know you're not a lawyer, but you're aware generally that there are laws and then there are cases where judges may interpret the law, fair?
Yes.
Okay, so it's your testimony that you were focused on the statutes, not the cases interpreting the statutes. Is that fair?
Yes.
Are you aware that forgery is a property crime under Michigan law?
I would have to look again at it.
You have to look again at what?
The statute, or any related materials that say that it's a property crime.
All right, let's do hopefully a simple one. I'm handing the witness what's been marked, or excuse me, hasn't been marked, just a copy of MCL 777.16N. I ask that the witness look at that. And Your Honor, I don't intend to introduce this. I think the court can take judicial notice of it. Do you have a problem with
It's a statute.
Yes.
The court can just tell them it's
Yeah.
property.
I'm just pulling up anyways.
So,
that? You see the second line that says 750.248 is the forgery statute, and it's classified as a property crime, Class E felony?
yes.
So we've established that this is a property crime. That means somebody has to be defrauded out of property, fair?
Objection calls for legal conclusion.
Did you wanna respond to the objection?
I don't think it's much of a legal conclusion to say the forgery statute being a property crime means somebody has to be defrauded out of property.
Well,
No, did you wanna make a statement?
well, I think that is an oversimplification of what the statute actually says. It doesn't just say like what we would think of as the general sense of property.
Well, I think what calls for legal conclusion is what is property. I don't
Right.
think him reading the actual elements of what's stated as a criminal investigator and the person who charged and said that there was probable cause that these individuals committed these acts. I think he can state whether or not he believes that this statute requires a defrauding of property. I think he can. He just can't define what property is.
I think we can state that it was property.
So then there's no objection. You can answer the question.
Yes.
All right. Now, when you read the Stevens memo on forgery, are you aware that he came to a different conclusion than you came to about these facts rising to the level of a crime under the Michigan forgery statute?
Well, my conclusion was based on the information throughout my investigation. His conclusion was based on the review of the information that he had at that time. So does that answer your question?
Kind of, but it's a little, my question is a little different. So in fairness, you reviewed more facts than he did. Is that what you're saying?
Yes, sir.
Okay, but you're aware from your review of his memo that as to the forgery statute, his review was in conflict with your conclusion that the forgery was meant. Fair?
I'd have to review specifically what he said in that memo, because again, I told you that I reviewed the memo, but I don't recall specifically what he said in there.
All right. But you're aware that his conclusion was that the forgery statute was not met here based on his review of the evidence at that time.
I'm aware that they declined, or he declined to authorize charges.
Which is in conflict, is contrary to your decision, right?
Yes, I don't have the decision to authorize charges again.
You ever submit an affidavit to a judge and the judge said, nah, I'm not gonna authorize charge in your years of being a cop, a police officer?
I don't recall.
Have you, when you looked at the forgery statutes, are you aware that a forgery occurs when somebody makes a false written instrument for either a pecuniary gain or exposes someone else to a financial loss? In your investigation and your research of the law, did that come up in your research?
Yes.
Are you aware that there is no property interest in an elected office?
I'm not aware of that.
Do you think there is a property interest in an elected office?
I don't know. To answer your question, I don't know.
Is it fair from your investigation that no property was taken in respect to this case?
Property was taken, you mean like stolen?
Yeah.
No, there was no property stolen.
Do you agree that Ms. Burden received no financial gain?
Yes, I've already said that. I didn't come across any evidence to show that she received any financial gain.
Right. And it is a little duplicative, but you answered that question with respect to another individual, so I want to make sure I asked it for Ms. Burden.
Understood.
Okay, let's turn to election law forgery. That's MCL 168.933A. Are you aware that the Hingham County APA Stevens memo determination was that those elements were not present here? Are you aware of that from your review of that memo?
I don't recall, again, what the memo said.
Okay. But they declined, correct?
Yes.
And they analyzed the election law statute, fair?
I don't know what they did.
You read the memo.
Your Honor,
Well,
at some point,
understood.
can we get to the effect on the listener?
Yeah.
I know we
Where's
do.
all the effect on the listener?
I've yet
He's
to hear
asking,
this.
was he aware? I mean, I think there's a buildup. He said he was gonna take the scenic route. I said I will allow him, so I don't know how long this memo is. I think it was attached to one of your, motions previously, so I have seen the memo, but I can't tell you how long. So he's gotta get all the statutes in the memo before he gets to the effect.
Yeah, and I mean, I'm happy to I can refresh his memory, we can look at it together. I will object to both of the Assistant Attorney Generals arguing with respect to one witness. I think they gotta choose.
That's in the court's discretion. I'll slightly sit down and talk with Ms. Wilkin if you don't want to hear from me. Okay, Your Honor. So this entire line of questioning only becomes relevant if Special Agent Schott says one thing, and that is, I read that memo and it had some kind of effect on me. So while I understand the court's previous rulings and statements on that, I think the court also has the discretion to ask that question first. We do not have to take the scenic route if that memo had no impact whatsoever on what Schott did. So I would just ask that the court exercise some discretion in that regard and have Schott answer that question first.
We already have one of those, which is he read the memo. Now, whether or not the memo in its entirety had any effect, I think that goes, I mean, that could be loaded. So I think what, and I could be wrong, I think what Mr. Giannini is trying to establish is how each of the statutes stated there had an effect on his decision.
I agree with the court entirely, and so if he says that, if the answer to that question is the memo had some sort of effect on me, absolutely, let's drive the scenic route together and ask all of those details, but the court has full discretion to have him answer that question first. Did it have any effect on your decisions in this case? And if he says yes, let's all drive the scenic route together, however long the court wants to give for that, but if he says no, we can move on.
Did you wanna?
Yeah, I like 17-mile drive, and I'm gonna ask the questions that I wanna ask, unless the court tells me I can't ask them, not the AG's office telling me.
Again, my understanding of where you're going with this is that, because I could foresee him saying, yes, it had an effect, or no, it didn't have an effect, but that doesn't, because he's not gonna recall exactly what's in this memo. What specifically in this memo was the effect? So it brings us back here, even if he says no, it had no effect, that doesn't mean that he didn't review any one of these statutes and that these questions he's asking won't be relevant to where he's trying to go.
Those are different questions, Your Honor, and I agree with the court entirely. I'm just trying to move this along because it all started because we were going that route of effect on the listener. So if there's no effect on the listener from the memo itself, then by all means, ask about the statutes in general. That's a different line of questioning. I'm simply trying to close this down in terms of the memo, that is all. And it is much less an evidentiary objection and much more just a friendly suggestion in terms of judicial economy. So if the court doesn't like it, I'll gladly sit down.
This is what, day 6 or 7 of half of a preliminary examination.
Yes, Your Honor.
We haven't rushed this long, we can't start rushing now.
And Your Honor, and I respect Ms. Chartier, I don't want her opinion too, but let me, if I may, since I'm standing. You started this proceeding with an admonition that we're in a criminal case involving 8 felonies, some 14-year felonies, and we need to take this seriously. And I'm taking this seriously, and if I want to take the scenic route, as long as the court indulges, then I think it's in fairness to my client that we do that.
It also, it sounds like the court is allowing the questioning, but it also goes to impeachment. With all due respect to Agent Schott, a lawyer, a seasoned prosecutor, wrote a detailed memo with statutes and case law analyzing each and every charge. And if the agent is saying he reviewed it and it had no impact on him, when he's saying all the research he did was just pulling up the statute and that's it, I think that absolutely goes to how this investigation starts and then how it has rolled to the point where we are, where 15 people face 8 extremely serious felonies. Nothing further, Your Honor.
You can continue, that objection's okay.
Thank you. Okay, election law forgery. Let's try to dig in a little bit there. Are you aware that that was recently passed in 2018?
Yes.
And even the predecessor statute, which is MCL 168.937, that was only prosecuted 2 times. Are you aware of that?
No.
Okay. I know you said you didn't look at cases. I just want to make sure. One of those cases was People versus Pinckney. Are you aware of People versus Pinckney?
No.
Did you read that case?
No.
Did anybody explain it to you?
No.
How about People versus Hall? again, same questions. Nobody explained that case to you?
No,
So you have no idea what those cases were about?
no.
Would you agree that nobody was tricked or fooled by the alternate Republican certificate of votes, which is People's Exhibit 14? Do you agree with that statement or not?
Nobody was tricked or fooled by the certificate of votes. I'm a little unclear on your question.
Okay, let me ask you, if you read in the APA Stevens memo where he says, whether the Republican candidates were grandstanding or preserving their rights, nobody was fooled by their transmitted certification of votes. Do you remember reading that?
I don't, but as you just read it,
Do you disagree with Mr. Stevens' conclusion?
I do. That's why I presented the affidavit.
Did you notice where he said preserving their rights in his memo?
Yes, but you have to understand that when Mr. Stevens crafted that, again, it was based on the information. There wasn't all these interviews that were done leading up to the July 2023 charging. So there was very little information that I saw that, where interviews were done or information or evidence was gathered, things like that. So yes, I disagree with it because while I respect it, it was written at a time in a place where maybe he had a certain amount of information in front of him, and he wrote that based upon the information that he had in front of him. Again, through my investigation, I wrote that affidavit based on the information that I had in front of me.
And you testified to that already. You had more facts than he did, right?
Yeah.
Because you investigated for a longer time, fair?
Yes, but I didn't see his investigation. I didn't see that whatever was done with it.
Okay, let me see if this impacted you in his memo. It says,
I just have a quick question.
oh, I'm sorry.
You say you didn't see his investigation?
Yes, Your Honor. I didn't see, I saw his memo, but I didn't see, like where an investigator was assigned to it, whether it was a special investigator from the county prosecutor's office and had done a preliminary investigation. Again, as I stated, I took over the investigation from Special Agent Cronin, in which I saw his investigation, but all I saw was the charging memo by Mr. Stevens.
Okay, but are you aware whether or not there was an investigation that Mr. Stevens relied on?
I'm not aware.
Okay, so when you made the statement that you had more facts than he did, you're not aware of that?
Right, yes.
Okay.
So, yes, and like I said, I wasn't certainly trying to second guess his investigation at all. I'm not aware of the facts or any investigation that may have been completed by Mr. Stevens or his staff that, brought him to that conclusion. Does that help?
I want to know if this impacted your investigation at all and the conclusions you reached in deciding to submit your affidavit. Mr. Stevens states, quote, the Republican candidates transmitted the certification of votes to satisfy their obligation under federal law if they became certified electors to vote. Do you recall reading that in the memo?
I don't recall the specifics of the memo.
Did that impact in any way? You may not have recalled the specific that I read. I can hand you the memo to verify it.
Understood.
But did that impact the way you proceeded in your investigation, knowing that this prosecutor is talking about obligations under federal law if between December 14, 2020 and January 6, 2021, they became the certified electors?
Yes.
Did that impact your investigation?
Yes.
pretty sure this is the first prosecution under this new forgery statute. Are you aware of that?
Didn't you just mention there was 2 other?
On the old statute.
Oh, okay, no,
You're not aware that you're
I'm not aware.
blazing new ground here?
no.
Are you aware that one of the elements that has to be proven under the Michigan election law statute is that the allegedly false document, equals Exhibit 14, has to relate to some purpose under the Michigan election law?
Yes.
You got a little problem there too, right?
I don't know what you're referring to.
Isn't the certificate of votes something that's required under federal law?
Yes, there is a certificate of votes that's required under the federal law.
Not state.
Well, yes, I'd have to go back and review some of the state statutes, but I believe the state statutes, I'm familiar with the ones just off the top of my head, which require them to convene at a certain place and time. But in order to completely answer your question, I'd have to, do some more digging.
That's fair. You can dig. So, let's just go through it. 3 U.S.C. Section 9 explains how presidential elections pass their certificate of votes. Are you aware of that?
Yes.
3 U.S.C. Section 11 provides for the process of how the certificate of votes gets delivered to the President of the Senate, the National Archives. Are you aware of that?
Yes.
Now, what you just testified to is kind of the mechanism for the electors to vote and where they vote and process under state law, right?
Yes.
But state law doesn't talk about the document, the certificate of votes, does it?
Again, I would have to refer back to that.
When you read the APA Stevens memo and he states, quote, the certification of votes is required by federal law, not Michigan law. Did that have an impact on you?
Like I said, I testified to the fact that and I can just say it now, the entire document did, of course, have an effect.
The APA Stevens memo impacted you.
Yes. It just like any other piece of evidence or information that I would come across in the course of the investigation.
I mean, you have another prosecutorial entity saying, ain't no crimes here, right?
Yes.
And so you gotta overcome that.
Well, again, it may be based on information that he had, but the information that I had at the time was very limited.
All right. Another element that the prosecution must prove in this case is that Kathy Burden acted with the specific intent to defraud, right?
Yes.
Are you aware that the APA Stevens memo concluded that, quote, there is not any evidence that proves this element?
Yes.
And he calls it nothing more than a quote-unquote political stunt, right?
I don't recall what he said.
Do you remember him quoting Professor Friedman, who's a University of Michigan law professor and constitutional law expert, who said that the, quote, Republican elector votes have no legal authority?
No, I don't.
And are you aware that Professor Friedman's statement goes on and states there's nothing preventing any group of 16 people from getting together, saying we're electors, but it doesn't have any legal force. Do you recall that?
I don't recall.
Now, Ms. Chartier asked you some questions about the Attorney General's public comments about this case. Remember that?
Yes.
And there was that brainwash comment, right?
By Mrs. Chartier?
Well, no,
Or-
Mrs. Chartier was
She was
recounting Ms.
recounting-
Nestle's
Yes,
comment
yes, I
about
recall
how the people who are charged in this case have been quote-unquote brainwashed, right?
Yes, I recall that.
And that they really legitimately believed and genuinely believed what they did, right? Basically, do you remember that?
Yes.
And the last thing she said was, somebody can't even plead guilty if they wanted to because they can't admit what they did violated the law because they still think they're right, close quote, right? Remember that?
Yes. I remember her talking about that. As far as the specifics on what was said in the video, I don't remember the specifics, but
And we already established that this is a specific intent crime.
yes.
How can someone genuinely believe something and yet have, at the same time, knowingly commit a crime to do that very same thing?
Are you asking me a question? Or?
I am.
Okay.
If somebody genuinely believes something, how can they do something knowingly wrong?
Well, I mean, if you walked into a bank and believed that money was yours, and you decided to say to the clerk, hey, give me the money, took the money, I don't know, you're calling upon me to create like some imaginary scenario, so I'm trying to do that and answer your question, is that?
Yeah, let's use your imaginary scenario. If I went into a bank teller and said, and I genuinely thought, that was my money,
Yeah.
and I took it, am I guilty for knowingly taking money that didn't belong to me?
Okay. Well, your ignorance of the law is
No
not
excuse.
Right.
Still negates my specific intent, Mr. Shah.
Okay.
Are you aware of the federal indictment against former President Trump that's pending in Washington, D.C.?
Yes.
Did you review that indictment?
Yes.
I want to know if you reviewed paragraph 10B, which states that I think it refers to some of the electors, quote, were tricked into participating based on the understanding that their votes would be used only if Mr. Trump succeeded in outcome determinative lawsuits within their state, close quote. Do you recall seeing that in the federal indictment against Mr. Trump?
I don't recall.
Do you see how the special prosecutor, Jack Smith, is saying that the Trump campaign tricked many of these alternate Republican electors?
You gotta have to object. It's hearsay. It's definitely being used for the truth of the matter asserted.
No, I want to know if it impacted him. Does he think that some of these electors, Ms. Burden in particular, was tricked into signing a document on December 14, 2020?
That wasn't your complete question. I think you repeat your full question.
Okay. So you already said you read the indictment, and we talked about the specific paragraph 10B, which refers to alternate electors across various states, right? Want me to read it again?
Yeah, just
Let me do that.
confused here. So we're talking about the Jack Smith?
Jack Smith, that's right.
Okay. And so I recall reviewing it. I don't recall specifics about it. It's been quite some time.
Let me read it again.
Well, Aaron, I'm going to object because it's still hearsay. And it can't qualify as a fact of the listener because first of all, the indictment came down after these charges were already left. So it can't be something that this investigator took into consideration when drafting his affidavit.
Your Honor, that may be fair, but I would hope that this investigator and this investigation team, if they are continuing to investigate after July of 2023, which is when these charges were authorized, which he's testified clearly he is doing on a daily basis, that they would take that information into account and maybe change their trajectory.
So this is being offered for the effect on the listener and not for the truth of the matter asserted is what you're stating. Objection overruled.
Do you think that Kathy Burden was tricked into participating on December 14, 2020?
No.
Do you see where this indictment says that the electors, at least some of them, were tricked into thinking that this would be used only if something changed after December 14, 2020 and before January 6, 2021?
I saw that.
You've heard testimony in this case that that's exactly what many of these people knew, including Ms. Burden, as
that again?
That the People's Exhibit 14
Yes.
was a contingent, a document that was contingent on future events occurring, specifically within that date range. You've heard testimony in this case about that, right?
Yes, I've heard that testimony.
You've heard people that you interviewed tell you exactly that, right?
Yes.
You heard the drafter of the document tell you exactly that, didn't you?
Yes.
And that's Mr. Cheeseman.
Yes.
Your search warrant affidavit, paragraph 23 states, quote, "The candidates for elector and the Michigan GOP leadership knew prior to their meeting on December 14, 2020, that there was no legal reason to create an alternate slate of electors," close quote, right?
Which affidavit are you referring to? The search warrant for, there was many of them here, so.
That's this one? No, it's the other. 17. No. I missed, I think it's in two places, so I got this one, I must take the question. Well, let me, hold on a second. It's 27. May I have permission to?
Yes.
Why don't you identify what I handed you, so I make sure I get it right?
Affidavit of probable cause.
Let's look at paragraph 27. That's what I just read from. I want to make sure that I read it correctly into the record.
Yes.
Okay, and that is, so, sorry, that's the affidavit of probable cause, and that is dated what? Just so the record's clear on what I'm handing.
7/18/2023.
Okay, so on July 18, 2023, you wrote that statement, right?
Yes.
Or maybe a couple days before.
I was gonna say maybe a day or two before, yeah.
Fair enough. And that's paragraph 27, so that would be one of the ones that you authored on your own without assistance from the Attorney General's office.
Yes.
Or they might have, did you say they, I forget, did you say they didn't or did maybe edit those paragraphs?
I don't recall that.
Fair enough. But that's essentially your section, right?
Yes.
All right. And you, again, the quote is that prior to the meeting on December 14, 2020, they knew that there was no legal reason to create an alternate slate of electors. Did I read that correctly?
Yes.
All right. Now, in fairness, you didn't interview Mr. Cheesebro until well after this, right?
Yes.
Mr. Cheesebro told you the exact opposite of that sentence, didn't he?
Yes.
He told you there was a legal reason, right?
Yes.
In fact, he told you that he believed there was plausible litigation that might be won between December 14, 2020 and January 6, 2021 when he drafted those documents, right?
Yes.
Do you remember, and I'm not going to get into it a lot, but Attorney General Nessel, when she got on TV and talking about this case one time, tried to dismiss the relevance of the 1960 Hawaii situation?
I don't recall that.
At a minimum, we know that you knew about that case and looked at it and pondered it prior to the affidavit you filed, right?
Yes.
Your Honor, I'm about to go into that. And I'm happy to keep going.
It's about 1 o'clock at the bare minimum.